When individuals with mental retardation are generally come in contact with the criminal justice system, one of the first things their attorneys generally do is request a competency evaluation. And I'm sure most of you out there that work with offenders with mental retardation are familiar with competency evaluations or have been involved in that process. And if not, we're going to learn a little bit about it here, because it does relate to forensic monitoring. Okay, so we're going to look at the chart that says evaluation of defendant's present mental condition. So the competency question is raised. That's normally raised by the defense attorney after talking to his client. He has some reason to believe that the individual may not understand what's going on, may not understand why they're in court or what they're charged with. So the attorney motions the court for an evaluation, then the court will order an evaluation, and the court orders an examiner to conduct the evaluation. The examiner submits a report to the court, and then the court takes that report. Copies are provided to the defense counsel and the prosecutor, and the court will hold a hearing on that. And if the person is determined to be competent to stand trial, the person then proceeds to trial. If the person is found incompetent to stand trial, one of two things can happen. Charges can be dismissed or there can be further proceedings. So let's turn to our chart that says disposition of defendant after competency hearing. The first box says if he's found competent to stand trial, he goes to trial. If the examiner in his opinion says, you know, I don't know, I can't decide at this point if the person's competent or not, the court can then order that individual to undergo continuing evaluation and treatment for up to 4 months, giving the examiner additional time to render an opinion as to whether or not the individual is competent. If the examiner finds initially that he's not competent at this, he or she's not competent at this point, but given a course of treatment, and treatment means several things. On the mental health side, treatment will mean medication, a medication regimen generally, along with educational classes to explain to the individual the court system, the players, the judge, the roles of the parties, the judge, the prosecutor, the defense attorney, what witnesses are, what a jury trial is, what a jury does, how a defendant, how a person, you know, what it means to have a defense attorney, how you interact with your defense attorney. So if the examiner says, you know, we think with some training this person can understand that and they'll be competent, then the court can order them to undergo competency, call it restoration training. And on the MR side, that looks like basically you're teaching. The examiner says we can teach the person to understand enough about the process so that when they go to trial, they'll learn, they'll know who the judge is, what a jury does, the roles of all the parties, and how to interact and work with their defense counsel. If a person is determined to be substantial probability that they'll be competent if provided a course of treatment with 1 year, they can be ordered into treatment. Most treatment is provided inpatient, either at a state psychiatric hospital or at a state developmental center. And the time of treatment can vary. If it's an aggravated felony, which are very serious offenses, things like rape, arson, burglary, murder, the maximum time for treatment is 1 year. For all other felonies, the maximum time for treatment is 6 months. For misdemeanors of the first degree, things like assault, domestic violence, those maximum time for treatment is 60 days. For all other misdemeanors, maximum time for competency treatment is 30 days. If the person is found immediately after the examiner does the evaluation, the examiner says this person is incompetent to stand trial and will not be restorable even if provided treatment for up to 1 year, even if that's the standard, this person is going to be incompetent to stand trial, then the court has 2 options. One option is to exercise continuing criminal court jurisdiction, and that is the criminal court kind of acts like the probate court. They keep jurisdiction over the criminal case and basically order the person to undergo treatment for the maximum amount of time the person would have received if they were convicted. So the treatment time is linked to the maximum amount of time the person would have been received if they were convicted of the offense. So you're talking about long periods of treatment, 8, 9, 10 years treatment time. Or in other cases, for felonies of the 3rd, 4th, and 5th degree and misdemeanors, the charges is dismissed and the individual, the court refers it to probate court to file a civil commitment. Okay. So let's turn to our third slide here. Incompetent to stand trial, unrestorable, continuing criminal court jurisdiction. For the court to invoke jurisdiction, it must hold a hearing, and it must determine two things at the hearing. It must find by clear and convincing evidence that the defendant committed the crime or whatever he or she is charged with. And the court also must find that the person meets one of these following two definitions: that they're a mentally retarded person subject to institutionalization by court order, or that they're a mentally ill person subject to hospitalization by court order. If the court cannot make these two findings, the court cannot exercise continuing criminal court jurisdiction. Charges are dismissed, and the only option at this point is for an affidavit for involuntary civil commitment or involuntary hospitalization to be filed. If the court does make these two findings, it can exercise continuing criminal court jurisdiction, and the court then at that time has the ability to commit the defendant to a state psychiatric hospital if they found the person was mentally ill subject to hospitalization, or to commit the person to a state operated developmental center if the court found the person mentally retarded subject to institutionalization by court order. And the Ohio Department of Mental Retardation does have individuals committed to it who are under continuing criminal court jurisdiction for serious felony offenses. Now, what happens after they're committed to the department here? Within 6 months after their initial commitment, we have to do a report to the court, which is in essence another competency evaluation, because that's the same question we're asking. Looking at again, we're looking at competency, and I don't think I said it before, but for competency, the things that the two questions is: does the individual understand or appreciate the nature and consequences of what he or she's been charged with? Do they understand what they've been charged with? Can they go through this court proceeding? And the other part of the question looks at: can they assist in their own defense? Can they work with their attorney? Can they do those things that a person needs to do to defend him or herself? Can they make decisions to accept pleas? Can they process information about plea bargains? Do they know what to do if they hear a witness telling a falsehood? Can they work with their attorney and strategize and put together a defense? That's what the competency question is answering, that question and only that question. So even under continuing criminal court jurisdiction, for those that report at 6 months looks at that, and if the person is determined to be competent within that time, then the criminal case, which is just kind of laying out there held in abeyance, resurrects itself, and the person then proceeds on the trial. If the person is determined, no, they're still incompetent, the examiner has to give an opinion as to whether they still remain to be mentally ill subject to hospitalization or mentally retarded subject to institutionalization. The other important thing about continuing criminal court jurisdiction is most people under this status end up in a state psychiatric hospital or state mental retardation facility, and the only way for them to have any kind of privileges to leave the facility, say to go to workshop, is just to get the approval of the court. So you have to motion the court to say, we want this individual to be able to go off grounds to attend workshop or to go off grounds to attend any other kind of programming. The court must approve it. The court can grant the individual conditional release, and what conditional release is: they're released back to the community to live in the community. They're no longer in the state operated facility subject to conditions, hence conditional release. And individuals on conditional release they're the ones that have a forensic monitor. There are individuals, as I said, there are individuals with mental retardation under continuing criminal court jurisdiction, and there are individuals with mental retardation who are subject to forensic monitoring. So there's some things that you and the MRDD system need to know about forensic monitoring, how to work with the forensic monitor, and how the individual service plan, behavior support plan, how all of that needs to work with the conditional release plan that the court is going to be looking to and that the forensic monitor is going to be looking to. So these are some things you need to do. You need to find out, once you have an individual, you find out he's going on conditional release, so the court's going to put the person on conditional release. You need to find out who your forensic monitor is and establish a relationship with the forensic monitor. Make sure the forensic monitor has a copy and understands the individual service plan. If the person has a behavior support plan, make sure the forensic monitor understands that. It's probably a good idea to have a team meeting to make sure everybody understands the various plans the person has. Don't assume that the forensic monitor has thorough knowledge of the MRDD system. If this person's if the consumer's on has waiver or waiver services, don't assume the forensic monitor understands that or understands how all of that works. You need to make sure the forensic monitor knows certain things. Like if the individual intends to move to another county, you need to make sure the forensic monitor knows that, because that may not be permissible under the conditional release plan. If the county board intends to close out the individual's case for whatever reason, you need to make sure the forensic monitor knows that. If the MRDD system or residential provider or somebody knows the individual is engaging in risky behavior or behavior that could be a violation of the law, you need to make sure the forensic monitor is aware of that. And if there's any change in services or providers, make sure the forensic monitor is aware of that.